Hello everyone, I'm Rong, a Chinese lawyer. Today I want to talk about the principles of format compliance and independence under demand guarantees. Okay, firstly, let me introduce a real case. This case involves three parties. The first party is a very famous South Korea company, Hyundai Motor Group Co. Limited. Hereinafter, I will call it Hyundai Group. The second party is a Chinese bank, Zhejiang Branch of Industrial and Commercial Bank. Hereinafter, I will call it the IC Bank. The third party is also a Chinese company, Zhejiang Zhonggao Power Technology Co. Limited. Hereinafter, I will call it Zhonggao. Hyundai Group concluded a contract on the supply of the diesel generating set with Zhonggao Company. The parties agreed that Zhonggao Company should apply to the IC Bank for issuing an irrevocable demand guarantee, which is an independent guarantee, as a payment method for underlying transactions. And the beneficiary of this guarantee is Hyundai Group. It was stated in the guarantee that, in the claim for compensation, Hyundai Group should submit the duplicate of the order clean ocean bill of lading. Afterwards, Zhonggao Company failed to make payments on schedule, and Hyundai Group made a claim for compensation to the IC Bank and submitted the duplicate of a straight bill of lading. And its claim was rejected by the IC Bank. Hyundai Group filed a lawsuit with the Intermediate People's Court of Hangzhou City, Zhejiang Province, and requested the IC Bank to reimburse $6,648,010 under the independent guarantee and the overdue fine. The IC Bank contended that the claim for compensation made by Hyundai Group according to the independent guarantee was an invalid claim. This case went through two stages, the first instance and the second instance. The first instance court dismissed Hyundai Group's claims, and the second instance court affirmed the first instance judgment. Both courts held that it was stipulated in the guarantee that the uniform rules for demand guarantees was applicable. So, in accordance with the provisions of the rules, under the circumstance where the terms and conditions of a guarantee were specific and clear, the guarantor only needed to consider whether the receipts were superficially consistent with the terms and conditions of the guarantee. The performance of the underlying contract was not a relevant factor to be taken into consideration in the examination of receipts. An independent guarantee was a contract with legally binding effect between the issuing bank and the beneficiary. Once the beneficiary accepted the terms of the guarantee or made a claim for compensation to the issuing bank, it showed that the beneficiary accepted all the terms of the guarantee and was bounded by such terms. In this case, the guarantee issued by the IC Bank clearly stated the requirements for receipts. Hyundai Group should provide all receipts consistent with the terms and conditions of the guarantee. Hyundai Group submitted the straight bill of lading, which was significantly different from the clean ocean bill of lading as requested by the guarantee. There is a difference between the two receipts in terms of international trade and maritime transport. The IC Bank refused the payment on the ground of non-compliance points, which confirmed to the stipulations of the guarantee. So, the first instance court dismissed Hyundai Group's claims, and the second instance court affirmed the first instance judgment. An independent guarantee has become a very common financial guarantee instrument in the international trade. In this case, the Chinese courts applied the doctrines of strict compliance and formal compliance, which effectively ensured the trading order of demand guarantees.